Good morning. I am Nancy Ancrum, the editorial page editor of the Miami Herald, and welcome to our Facebook Live version of our interviews with the candidates for Miami-Dade State Attorney, responsible for enforcing the laws of the state of Florida in this community. I'm going to be joined by Nancy San Martin, managing editor of El Nuevo Herald, David Ovalle, reporter who's also covering this race, and my editorial board colleague, Luisa Yanez. Let's get started. I'd like to introduce our candidates, the current Miami-Dade State Attorney, Katherine Fernandez Rundle.
Good morning, everyone.
Good morning. And her challenger, former Deputy Director of the ACLU in Miami-Dade, Melba Pearson. Welcome to you both. As I think I explained earlier, we will be asking you questions. Some of you will be, one of you or another might be asked a different question based on your record, previous quotes, and my colleagues will also be invited to participate in asking questions. I'm going to dive right in. And also, one more thing, please be succinct but brief in your answers. We have an hour and we want to make sure we get to as many questions as possible. Ms. Fernandez Rundle, you've been criticized for failing to charge even one officer in an on-duty fatal shooting, which has been the case among prosecutors statewide. You've countered that state law gives police tremendous leeway for their on-duty actions, especially when it comes to use of force. What has been your role in pushing back against excessive force? Where's your bully pulpit?
Well, it's a very important question for our community, and it's an important question for our country. And looking at some data, you will see around the country that in the last several years, thousands since 2005, 13,000 officers have shot or injured an individual, and yet only 104 have been charged and only 4 convicted. And our Florida is not much different than that. Like you said, in the last 30 years, we've had 1 conviction statewide, and that was 5 years ago. So what we have been trying to do over the time that we have these cases is point out and try to change the way in which we look at these cases. For a start, one of the first things we did was we asked for an independent investigation body, which is the Florida Department of Law Enforcement. And we brought them in around 2014. And when I say I used whatever influence I could to convince our police chiefs, because they had to be invited in, to use FDLE to provide an independent, transparent, objective outside agency to look and investigate these police shooting fatality cases and injury cases as well. The other thing we did was we really pushed in 2015 for body-worn cameras, because one of the things we tend to lack in a lot of these cases is the evidence. And so what we were able to successfully ask our local police departments, of which there are 35 in Miami-Dade County, to engage with body-worn cameras, and they have done that, and that's actually helped us a great deal. Not so much in the fatality case. The fatality case in West Palm Beach wasn't a video; it was a recording where everything was recorded. But it's really helped us with the cases where we have to prosecute police misconduct. One of the things I'd like to do is deal with the notion that our office, while we have not been able to break through some of the obstacles and barriers that tie our hands with respect to fatality cases, on-duty fatality cases, it does not mean that this office is not prosecuting police officers and correction officers who violate the law, no matter what it is. And a lot of those happen to be misconduct, brutality cases, excessive use of force that may not result in deadly force, in a fatality. And we've done that in about 500 cases since I've become the state attorney. And so when we look at that, it's very troubling to think that this office wouldn't, if we could, the laws have a lot of latitude. They give a lot of latitude to police officers. And I guess the underlying theory is that they need to protect themselves. Not underlying, it's clear. They need to protect themselves and to protect others. And so one of the things we're hopeful to do as we move forward, and there's an appetite now. Now people want reforms. And that's when we really have to seize this opportunity. We're in a moment for reforms in this country.
Okay, we'll be able to discuss reforms in just a little bit. Ms. Pearson, the incumbent says that state law does give police broad leeway in the use of deadly force. Since that's the case, are you saying you would risk bringing cases to trial that you stand a good chance of losing?
So let's be clear. Yes, there are some obstacles as presented by the state of the law at this time. But that does not mean that cases cannot be filed. I believe that it was the Herald's reporting that revealed that since 2016, there have been 73 cases of police shootings, not all fatal, some non-fatal. But when we're looking at that large number and not one case gets filed, that to me is problematic. Listen, having been a litigator for many years and have tried these tough cases, stand your ground, different types of cases, there's never a guarantee that when you take a case in front of the jury that you're going to win. I have always told my next of kin, families that I've worked with, listen, I'm going to fight as hard as I can for you. But at the end of the day, the fate is in the hands of 6 or 12 people, depending on the case. The legal standard is not, are you going to win this case? The legal standard is, do I have enough evidence to present this case and present it and prove it beyond a reasonable doubt? Just because I believe that I have enough to prove beyond a reasonable doubt doesn't mean the jury is always going to agree, but sometimes they will. And you can't use the winning metric as the determining factor whether or not to file charges. You have to look at, do I have the evidence? And for instance, the Jesus Benacall case, as well as the Darren Rainey cases, which the Miami Herald reported on extensively, were clear missed opportunities. And those were indications of times where we had evidence, we had video, we had testimony, charges could have been filed, but they were not. And that trend has to change. We need to be a leader, not just wait and try to take advantage of a moment. We need to be at the forefront of fighting for what's right.
Thank you. Ms. Rundle, you did decline to file charges in the egregious scalding shower death of Darren Rainey while in prison. The medical examiner found no evidence that he was burned to death. What were your initial thoughts about that finding? And was there no other avenue for you to pursue those prison guards?
You know, when you look at the Darren Rainey photographs and understand how our mental health persons are treated or were treated, it's gotten much better since Darren Rainey in our facilities. It was really heartbreaking to see that. But in the end, the law in Florida is that the medical examiner for each county, each jurisdiction, has under the law the obligation, the duty to determine the cause of death and the manner of death. And as you just said, in this case, the chief pathologist for this community, as happens throughout the state of Florida, ruled that the cause and manner of death was not a homicide. And she even went further to say that there were no thermal injuries, there were no burns on his body. She even went on to say that his feet, had he been in a scalding hot shower, as we are told, he would have had burns on his feet, and he didn't. And so when you have that kind of ruling from an independent, objective person who is an expert, this is an expert, she's our expert, our chief pathologist on all of our other homicide cases, our hands were really tied to be able to file any kind of a homicide case.
Thank you. Ms. Pearson, you touched on this, and of course it's easy to Monday morning quarterback issues such as this. However, do you think there was would you have looked for a credible avenue to pursue those punishment for the guards?
Yes, absolutely. For me, I didn't approach it from a Monday morning quarterbacking point of view. I reviewed the medical examiner's report. I reviewed the closeout memo. I reviewed the witness statements that were publicly available. And using that, based on my knowledge of the law, based on my knowledge having tried very difficult homicide cases over the course of 16 years when I was a prosecutor at the Miami-Dade State Attorney's Office, I looked at that case and came to the conclusion that manslaughter charges and culpable negligence charges could have been filed. Agreed. The cause of death was not homicide. So obviously you could not file first or second degree murder. But if there is a finding in the medical examiner's report that indicates that this was accidental in nature, that fits with the requirements for a manslaughter charge. Additionally, 2 other autopsies were commissioned by the family, and during the course of the investigation, that came to a different conclusion, that was closer in line to homicide. But be that as it may, there was still a clear opportunity, because no matter what, nobody is in a shower for 2 hours. Certainly not in a prison, especially when in the average prison shower is 6 to 10 minutes, right? As dictated by the guards. And at the end of the day, it is very clear Darren Rainey would still be alive today if he was not placed in that shower for 2 hours. Period. End of story. So the culpability clearly lies with these guards, and this was a missed opportunity. Charges could have been filed, and this case could have been successfully prosecuted.
Thank you. Louisa, do you have a question?
You're on mute.
If you had to do it again, Ms. Rundle, would you take exactly the same position on the Darren Rainey case?
I would, Louisa, because, we don't, there were 4 correction officers, 4 African-American correction officers. You don't take a chance and you don't put their lives upside down on a case that you can't prove. You don't have the evidence. The evidence is actually against you in that case. And to me, that would just be inappropriate to do by all of our ethical standards, by all of our obligations. And, I think the one good thing that came out of this was all the reforms that took place. The Miami Herald's reporting really caused a lot of changes with experts in these facilities to take care of our mentally ill that are in our facilities.
Thank you. Ms. Pearson, you have criticized the cash bail system. Tell us why you think it's unfair. Also, what other criminal justice reforms would you fight for? And would direct filing of juveniles be among them?
Yes, thank you so much, Louisa. I have a huge problem with the cash bail system. It creates 2 systems of justice, one for the wealthy and one for the people who are less resourced. And it's been made abundantly clear in the last few years when we see the Harvey Weinstein case, when we see Jeffrey Epstein, which, on Netflix, there's a very painful recitation of everything that had been going on in that case for so many years, and how his wealth gave him the ability to be protected and enabled him to bond out and still continue to prey on the community. So it is clear that the concept of risk is not tied to money. So we need to move away from that as a community. So I intend, when I win the race for state attorney on August 18th, I intend to end the use of cash bail for non-violent offenses, for people who do not pose a risk to the community, and also work on addressing the underlying issues that got them into the system to begin with. Really get back to that place of working with programming so that, again, people are making their lives better during the time they're waiting to resolve their case. And then on the back end of it, they don't have the collateral consequences of, they were being held in custody before the trial. So they lose their job, they lose their housing, they're unable to provide for their families, they're separated from their children, which then creates other collateral consequences where you may have kids more likely to be involved in the criminal justice system. All of this results in destruction of families and making our communities less safe. So that's why I see bail reform is so important, as well as juvenile justice, ending the use of direct file, except when mandated by law, and aggressively handling police misconduct and public corruption cases.
Oh, I was going to ask Ms. Rundle about the cash bail system, her
Yeah,
position.
okay, so let's kind of like, that was a whole bunch of a lot of issues in one answer, okay? The one area that we've really come a long way in as a community is in the area of non-monetary release. So let me just start with a few things in that regard. And I just think, my opponent is just out of touch and doesn't realize what has been going on in this field. So first of all, most pretrial release is structured by either the courts or it's structured by state statute. So a lot of the bail reform that has been talked about has to come from those two entities as well. So what I can do as an office is already what she said she would do. And that is, we have been supporting non-monetary cash bonds or release on your own recognizance for low-level, nonviolent offenses for quite some time now. And we've been expanding that extensively. And in addition to that, there is a cashless bond ad hoc committee. And this is being led by our Chief Judge of the Administrative Division of the Courts, Daniel Jr., who is the head of our Department of Corrections. And that department supervises all of the pretrial release programs, which has been expanding. And just to give you some example of just a contextual relationship, in 2008, there were approximately 7,000 inmates in our local jail. We're down to about 3,200 now. There are 3 facilities have been closed. And a lot of that is because of a couple of contributing factors. One is our support for civil citations. Quite some time ago, I think 2012, we started actually keeping records, but we suggested that the police stop arresting where they can, where it's not a threat, where their safety is not endangered, nor the public's, and using civil citations instead of arrest. Just during that period of time, there have been about 40,000 folks, adults, who have been cited as opposed to being arrested. In addition to that, we have a lot of pre-arrest diversion programs, especially for drug cases and of that nature. And then in addition to that, the bigger picture of what we're doing about non-monetary, how we do that across the whole spectrum, not just the ones below lines that we're talking about. What is that system? What does it look like? How do you keep a community safe? And can we rely more on release programs, pretrial release programs? And so this committee has done incredible research. We've looked all over the country. My office has talked to Justice Collaborative and now the Wren Project and asked them to guide us with technical assistance. How do we get to that bigger group and the more serious offenders? In addition to that, as a circuit, the chief judge, myself, the public defender, we've all applied for a research project and we got it. We are going to become a learning site, which basically is going to look at, it tells us all the reforms, which by the way, is really just happening now in different parts of the country. And I'm pretty aware of that through my colleagues, my association with my colleagues. And we qualified for that grant. So the technical assistance folks have started to come down. COVID has sort of put things on a hold, but we are going to be moving in that direction on the larger scale. In the meantime, let me just share with you, especially the listeners, so they might be concerned about being released, what we've seen in some other jurisdictions.
Right, and please start to wrap up. Thank you.
Yeah, sorry. We have increased, meaning we, the whole system, to use the pretrial services alternative to incarceration. And just last year, there were about over 8,000 who participated in that program. And the rearrest rate and the failure to return rate is really low. It's like around 10%. So that's all good news.
Okay, thank you very much. Along those lines, I'd like to ask both of you, I'll start, and if you could just be brief here. Given civil citations, given what state law now means for possessing marijuana in many cases, how have you pivoted to accommodate that? How is your office treating people who are found with marijuana in their possession?
Well, a couple of things have happened. First, you mentioned civil citations. That was one of my first efforts, was to convince our local police, where appropriate, where they can, to issue civil citations instead of arrests. Now, one of the things we confronted is, for instance, I'll use Miami Beach because they know. Miami Beach wanted marijuana prosecutions to occur, and other jurisdictions were using civil citations, whereas Miami Beach would not. What I could do as an office, I can't force local police departments to do much of anything. I can influence them, and I can tell them what I'm going to do when it gets into the system, which is what I did do, which was we are going to treat them all the same. We're ministers of justice. So whether you got a civil citation or the police decide to arrest you, once you get to us, we drop charges. And we did that for quite some time. Last year, I believe, we made an announcement to all of our police departments that we would not be prosecuting simple possession of marijuana cases. And so far, that has been the law of the land, at least if you like, for this jurisdiction. And so far, I don't see that it's had any negative impact.
Okay.
So my feeling is to continue in that regard.
Thank you. Ms. Pearson, how would you handle such cases?
So first of all, just want to drop a little bit of context to all of this. In 2018, when I was part of the leadership team for the ACLU of Florida, the ACLU released what was called the Unequal Treatment Report that examined racial disparities within the Miami-Dade criminal justice system and found that Black Miamians had almost 3 times as worse outcomes at every stage of the criminal justice system, and that Black Hispanic Miamians had almost 6 times worse outcomes. And why that's important to note is while these civil citation programs are moving forward, they happen to be disparate in the way that they're being enforced. So folks that identify as minorities don't seem to get the civil citations the same way that other people who are not minorities are able to get those citations and be diverted out of the system. So I, first of all, would end the prosecution of misdemeanor marijuana, but I would also go further with regards to possession with intent to sell, not actual sale, but possession with intent, because too often the amount of marijuana found on some folks is consistent with personal use, but however, they're treated in the system as if they're actually selling, which is not the case. So I want to really move forward so that we are centering equity, especially as we look at the national landscape around cannabis enforcement and how, Colorado, California, other states are moving forward as other states, unfortunately, are not catching up as quickly. But that is definitely going to be something very much centered within my administration, is ending the criminalization of cannabis and really pushing in conjunction with other lawmakers, other folks who are similarly situated, to push and make sure that we get to full legalization in this country, because that's where we are.
Thank you. Ms. Pearson, despite some skepticism and a somewhat wobbly relationship occasionally, Black support for the incumbent remains relatively strong. How are you making the case for their support of you? In addition, because the two of you are both running as Democrats, this is an open primary, which means that Republicans and independents will be voting in this race. How are you making the case there?
Certainly. So a lot of this, of course, has been made a little bit more challenging as a result of the COVID-19 virus. But the one thing that I've been able to enjoy is a lot of support amongst the legal community, as well as the activists and just everyday folks, right, who are ready for a change. I think that, unfortunately, a lot of the messages of change, that the people want change, has not been rising through the media in the same way. But every time I'm able to go out and interact with people, they're super excited for the possibility of change. They are ready because many people feel that 27 years is just too long. They want to see term limits. They want to see new and fresh ideas, and someone who really embodies, where we are as a country right now. So I've been able to communicate with a great great number of people. I spent the weekend from Miami Gardens all the way to Homestead, supporting families who did not get justice and closure under this administration and who are African American and of other nationalities as well. Additionally, I have been very intentional about messaging different groups of people because, again, the message of change resonates, and the message of criminal justice reform is not just a one-party issue. We've seen that with the Florida First Step Act, with the federal First Step Act, which was bipartisan in nature. And it shows that Republicans and no party affiliated folks really want to see change and want to see robust criminal justice reform, not just a little bit because, oh, wait, I may have a challenger or, something along those lines, but they want to see true leaders in pushing forward change and taking us into the next century.
Thank you. Ms. Fernandez Rundle, how are you addressing, to the degree that you can within your office, the criminal justice disparities that studies do show exist, from treatment on the street by police officers, clearly not your responsibility, to all the way to how they are treated and sentenced once they get to court?
Mm-hmm.
How are you dealing with such disparities? Do you see it? Do you see the possibility of it? And what are your remedies, if any?
Mm-hmm. Well, we do, and disparity does exist, and racial and ethnic bias is real. And so to the extent that we can have a role in that and address it when we see it, this is sort of how we do that. Number one is we have found that if you have a very diverse office that brings their experiences and their feelings to the table, they're going to be better able to relate and understand some of those bias and hopefully break some of that disparate outcome. We're always about what's a just outcome in a case. And I'll give you an example. The Sarasota Herald Tribune did a study, an award-winning author, Michael Braga, and he looked at sentencing throughout all of Florida. And he found that the most fair sentencing in all of Florida came from here. And he went further to say he believed it had a lot to do with the diversity of the state attorney's office and the diversity of the public defender's office. Now, also, when we see something that is completely racially based, like what happened in Biscayne Park, we don't hesitate to take action. For those of you that may not know, that was the case where police officers, at the direction of their police chief and major, were told to arrest people and say that innocent people had committed certain burglaries and crimes that they had not. We worked with the feds on that case. We were part of that prosecution, but more importantly, we pulled all those A forms and all those arrest forms, and we looked at all of them. We ended up absolutely dropping all those cases. The other thing is that so much of what happens in the social injustice arena, where there is a lot of disparate, it comes to us in the criminal justice system. So we can't always, we're not the ones that make the arrest, we're not the ones that bring them into the system. However, what we can do is we can find alternative pathways to that constant, old-fashioned, traditional, incarcerate everybody. And that's, I think, one of the things that I'm most proud of this office for doing, because we have, for the last several years, we've created all these alternative pathways. And doing that, we've been actually able to prove that we can reduce crime to the lowest where it's been in 30 years, and also reduced it by 70% by creating these pathways through diversion programs, through mental health programs, to addressing underlying addiction issues. And we can create those pathways. And what happens is we found that crime didn't go up. And that over-incarceration was not the answer for all these offenders. For the violent offenders, for the repeat offenders, yes, that's the only way really to somewhat incapacitate them. But for the large number of offenders coming into the system, that's what we've created. And that's what we call smart justice, Miami style. I know I'm going on too long, but we have a reputation in this country and in this state for creating those alternative pathways to incarceration, thereby reducing what was a traditional reliance on over-incarceration.
Thank you. David Avaya, you have a question?
Yes, thank you. Miami-Dade accounts for a huge percentage of the money that is spent on death penalty cases for court-appointed indigent clients. And that is something that's been going on for a long time. And oftentimes it takes years. I've seen cases that go 5, 10, even more years before death penalty is waived. From both candidates, but I'd like to start with Kathy. What can your office do to better streamline that process so that the death penalty is appropriately applied and waived in cases in which everyone knows the death penalty is not going to be sought?
The death penalty, in my mind, has always been something that is really painful for family members, because you talked about how long it takes. And the average case is like 14 years to go up through all the appeals, get it through the courts. And the appellate courts have been remanding a lot of these cases back, which is really disappointing for surviving family members. I would not be a person to vote in favor of the death penalty by any stretch of the imagination, but it is the law. So what we do is we try to apply it in a fair and continuum basis. We have some of the best eyes and ears that try these cases. Death penalty cases are litigation specialists all to itself. And so because of constitutional reasons, continuity is fundamental. So every single one of those cases, and I know you've looked at those, David, through the cost. The cost is unbearable for the state of Florida and for our circuit. But in terms of how we can streamline it, we started looking up front for mitigating factors and not waiting for the defense to get us evidence of mitigating factors. So the obvious ones like age and mental health status, we pretty much know how to streamline those. There are other mitigation factors that sometimes we just wait for the defense to get us their mitigation packages. Having said that, we have started a streamlined process through our legal division to sort of monitor the cases and where they are, who's on top of them, who isn't. Our courts, right now, we're on hold. We don't even know we're going to go back to jury trials. So I'm not real optimistic about those cases moving more quickly through the system. Unfortunately, remember, delay is a prosecutor's worst enemy. And these cases are delayed in the system, and the defense bogs them down a lot. And the courts care about them because it's the severest penalty that exists in our system.
Ms. Pearson?
Yeah, so unfortunately, I think we're in a situation where, as we're looking to, my opponent is looking to streamline now. It's a little late because, 27 years later, I think we need to be very radical in our approach to be able to address these issues and address the waste that comes from handling these death penalty cases. So one of the things that's sort of standard operating procedure is going to the grand jury for the death, basically to file the first degree murder charge that would allow for the death penalty to come into play, filing and going to the grand jury very early in the process, or filing that notice of intent to seek death, which disqualifies so many other attorneys from being able to even get involved with the case. I think if we're able to delay that process and really do all of the upfront work before even deciding whether or not death penalty should go on the table, it is much easier to waive it in advance and decide on a different path than to have gone to the grand jury, gotten that indictment, and now 5-6 years later, oh, wait a minute, now let's see if we're going to plea it to life or something along those lines. So it is time to really revamp the way that we approach death penalty to be able to address a lot of these issues on the front end, and also to really restructure how the office handles death penalty, from it being a committee of folks who haven't really tried cases or even homicide cases, in decades, to having a centralized committee community that can look at these cases who are still very trial active, who are still very much dialed into the law and everything that's going on, so that they can make rotating decisions. And that also becomes a pathway to promotion, so that we can use that as a recruitment tool or as a tool for retention. And lastly, recreating the homicide unit, which was unfortunately disbanded as a result of sexual harassment and a whole bunch of misconduct and a lot of problematic things that were happening in that unit. But reconstituting that homicide unit to be able to focus solely on those cases, and then that could also help expedite the process and reduce the cost, as well as bring closure to the families and people involved.
Okay, thank you. Nancy San Martin, you have a question?
Yes, thank you. This is also for both candidates. I'm curious to know what your thoughts are in terms of what are the most urgent needs, changes that are needed at the state attorney's office, and what are the primary obstacles you see for making those changes happen?
Ms.
That's
Fernandez.
for both candidates.
Oh, okay, I'm sorry, I
Yeah.
wasn't sure who that was directed at. I just, real quick, I just got to say something. That answer on the death penalty really shows the lack of executive experience, because what she just described is not, all cases have to go in front of the grand jury, and that we have to file an intent within 45 days as to whether or not we're going to seek death penalty. And I don't want a hodgepodge of different people looking at these cases. I need continuity. It's the constitutional fundamental pillar of those death penalty cases. So I just want to make sure that we corrected that to some extent. Changes, reforms. We need a lot of reforms. And I think that one of the things we need to do is going to be in the area of policing. I'm sure we're going to get to policing in a few minutes. But I've been working with the pastors groups. We did a prayer walk together, and I've been working with the Dade chiefs of police. I've been talking to legislators. And so right now, as I said sort of in the beginning, this is a time for real concrete, meaningful reforms that can take place, both within policing. And by the way, the police are the first to say they want to do this. There's been a lot of discussion by the Association of Police Chiefs, Association of Sheriffs, and locally, as I said to you, they're embracing a lot of new changes that they want. They want to have better relationships with their community. Though they don't like what we see in the national news either. And so some of the things that we're actually talking about are things like a statewide ban on chokeholds, a statewide ban on knee on the throat. We're talking about 8 can't wait. I don't know if any of you are familiar with that. It's got a lot of qualities. It's 8 different things, and it talks about a duty to intervene. When you see someone is being injured or killed in front of you as a police officer, you have a duty to intervene. Not only is it a moral duty, but let's create a legislative duty. We also have been talking a lot about community policing. We expect police to go in when there's a problem, but they should be there all the time, building relationships. We also need better training in de-escalation. Right now, the training that they utilize spends more time on teaching officers how to write reports, for instance, than it does in learning how to de-escalate a situation. So that these flashpoints between someone who's being arrested and a police officer don't escalate into some of the terrible results that we have seen. And one thing we know works, we know that training can work, we should make it mandatory, is because in the area of mental illness, CIT, crisis intervention training, has worked. We now have thousands of police officers that have done the training, others are actually certified in that training. So when someone is going through a mental health breakdown and a family member calls, a police officer who is trained to learn how to de-escalate that situation has made a huge difference in the quality of life, in the reduction of arrests, and in getting those that need that treatment onto the right path. So those are just some of the police reforms. I hope at the end of this we'll come back to some others that we highly suggest that deal with other legislative issues like definition of excessive use of force, fleeing felon to be eliminated in our view, unless the person's armed and is in the process of going to hurt someone else, of course. So those are some of the reforms that I think are really needed. And we're ready as a country, and we're ready as a state, and we're ready as a community to insist on those reforms taking place.
Okay, Kathy, one thing that I know, I'll let you go in just a minute, Ms. Pearson, but one thing that Nancy San Martin did ask about looking within your office.
Mm-hmm.
Are there any specific challenges that you would want to take on within your office during a next term? I'll add on to that. You know, you talked about diversity. How many of your attorneys are African American or from Caribbean American? But if you could address Nancy San Martin's specific question, briefly, that'd be great.
So one of the things we're experiencing now with a lot of our young lawyers, or old lawyers for that matter, any of our lawyers of color, whether they're Hispanic or they're Black or they're Caribbean, you know, I'm sorry, I meant to say African American or Caribbean. They are really suffering right now individually. We've been doing these healing hours in the office with them, trying to let them express their experiences. And some of them are, you know, they're somewhat confused by what they're reading about that's happening in the country. They're in a prosecutor's office. So we're doing these healing hours and letting them talk about their experiences. But I really think we need to do more. I think we may need some more professional sort of intervention. We had Dr. Marvin Dunn come and speak with us, and it seemed to help a great deal. But I really think that's one of the most immediate challenges for these lawyers working in our office, working in this community, working with police, and having their experiences understood and reconciled with what their role is as a prosecutor. The other thing is, you know, we're not talking about COVID right now, but the real challenge is around the corner. And we as an office have just completely changed the way we do business. Much of it is good. A lot of the reforms that came out of the necessity of COVID has pivoted us, for instance, to a paperless way of filing cases, taking testimony, swearing folks in. But, you know, we don't have any trials moving right now of any significance. We're at a very low rate of moving cases through the system. And it's not the courts. I mean, even though the courts are still in phase 1, we were getting ready to go into phase 2. It's just that the capability of being capacity for doing trials is at a standstill right now. So I am very concerned about, as are my stakeholder friends, about what we're going to do as an office. How are we going to be changing the way we do business in the next 6-9 months to a year? Those are some of the things that are really challenging for us right now.
Okay, thank you. Ms. Pearson, Nancy San Martin asked about changes within the office, but then also you can slide into police reforms that you would want to see, because Ms. Fernandez Rundle did address those pretty comprehensively.
Sure. And before I launch into that answer, I have to actually highlight how, unfortunately, my opponent is out of touch, because you can go to the grand jury at any time on a first-degree murder. So, and having tried those cases in recent history, you know, I remember the protocol. So going with regards to the changes I would implement, day one, I would end the direct file of juveniles to adult court for the majority of offenses, except when mandated by law. When we look at between the years of 2015 to 2018, and we see that 96% of the kids who were direct filed to adult court for nonviolent offenses were kids of color. Clearly, there's a huge problem with regards to how justice is being dispensed and whether or not it's being equitable. So that's one of the first changes that I would implement. The second change I would implement on day one is to revamp the way that our supervisors supervise, right? So our division chiefs right now, unfortunately, have a full caseload of homicides and other serious cases, and then are expected to supervise on top of that. Now, when you have a situation of new prosecutors coming in, you know, wanting to do the right thing, don't get me wrong, But unfortunately, issues of implicit bias may creep in, or not understanding what's appropriate in what types of cases, or not understanding the environmental impacts that living in certain communities can create. While you may not necessarily be someone of ill intent, you may be in a situation as a result of where you live or something like that. You need a supervisor that's able to really sit with you, guide you, mentor you, review your cases with you, and help you figure out a strategy to move forward. That is sorely lacking, unfortunately. Again, just a lot of it based on time constraints. So I want to revamp the way that we're supervising so that we can have better outcomes for the community. And also our prosecutors aren't at the place where they're so overwhelmed and they have nowhere to turn, so they give up or they leave, or both. So there's that aspect. Also, when we're talking about policing, there's a number of things you can't control externally, but internally, we can be much more aggressive in the way that we approach police misconduct and police homicide cases. So again, looking at Darren Rainey, looking at Jesus Menacol, who was sexually assaulting women and girls in Hialeah and faced absolutely no accountability by the Miami-Dade State Attorney's Office. So really turning that focus and having dedicated prosecutors that they only work on police shooting and police misconduct cases. I've also been in discussions with candidates in Broward County who are of the progressive mindset to see if there's a way that once we both win our races, we can exchange police shootings. Because again, the community looks at these cases and think, oh, well, you guys were all in bed together, so therefore, how can we expect justice to really happen? But if we have a situation where we're investigating cases in the next county over, that can go a long way to building that bridge of transparency and accountability, and for the public to really feel comfortable that their needs and concerns are being met. And lastly, and this may seem like a minor issue to some, but really revamp the use of technology. You know, this pandemic, the good thing about the pandemic, probably the only good thing, is that we realize there's this thing called Zoom, right? And we can meet with people and interact with people and make, as a result of this, we can use technology to make the criminal justice system more accessible to more people, so that if you live in Homestead, you don't have to drive or find transportation all the way to the Justice Building or to the state attorney's office to give testimony. That way, you don't have to take off work, you know, so it makes the system more accessible to more people, as well as trimming down the time it takes for cases to be worked on internally, where you're not looking for paper files and digging through, you know, piles and all of that. You have everything you need in a streamlined fashion. And many other jurisdictions in Florida already have implemented this technology. We're just behind the curve when it comes to that.
Okay, couple of responses, may I?
Yeah, please.
Okay, so first of all, yes, all first-degree murder cases go to the grand jury. That's by law. I want to take exception about the comments about our division chiefs. Our division chiefs in our office are the core. They're the heart and soul of that office. They work very hard and they are mentoring all the time those that are in their division. They supervise them, they mentor them, they nurture them, and they're constantly giving advice and supporting all the lawyers that work underneath their umbrella in the court system. The other thing is that in terms of technology, our IT division is by far the best in the state of Florida. It's always been the leader of all the offices in Florida, Hamilton Davis and Harry Fisher. And had it not been for them, a lot of the advancements we made quickly to go into complete, as I said to you, paperless filing and technology. And we've been doing remote calls to witnesses and civilian as well as police officer witnesses for quite some time now. And it was our IT division, our technology experts that came up with about 135 cameras and laptops and gave them to the courts so that they could go virtual with us on a lot of the things we need to do. It was that same IT division that gave away cameras and laptops to the jail. So we didn't have to be transporting inmates back and forth so that they could actually do it remotely. So the whole concept that this office is not advanced in technology is just It's just false. That is one of the best teams. You can ask any stakeholder in the system about the quality and the advancement of our technology team at our office.
Thank you. This question's for the two of you. Some people call it a no snitch culture. I tend to call it a credible fear of retaliation for coming forward with information about a crime. How does this impede your ability to solve crimes? I'm asking this of Ms. Fernandez Rundle, to solve crime, to get gangs off the street, just briefly.
It is a real issue, and it has been for quite some time. And when I talk to community members, when I'm in the community and they're complaining, for instance, about gun violence or mothers of murdered children, I meet with them and they talk about why we can't make cases. And a lot of it is true, and that they're afraid. And sometimes, you know what, with reason, because there was a long time, and it's still occurring, where cases weren't being made, arrests weren't being made. So, you know, the citizen out on the street says, I know who may have done it, but I'm not going to say anything because that person's going to be out on the street living next door to me immediately. And so what we did as an office, what we tried to do was, when we looked at all the violent crime that exists in our community in terms of gun violence, contact shootings, homicides, we found that there were pockets, right? Neighborhoods that were really being terrorized by gun violence. So, and we were losing, there were no arrests being made. So that meant the shooters and their guns stayed on the street. And B, the people just continued to live in fear and didn't want to cooperate. Even if they knew what it was, they weren't going to quote unquote snitch or work with the police. So what we did as somewhat of a solution to that, and trying to address that issue, is we started something called the Gun Violence Initiatives. I'm very proud of this. These folks are incredible. So what that is we went into Northside, which is between 7th Avenue and 32nd Avenue, 59th Street on the south, 79th Street on the north. And we embedded there lawyers, victims advocates, case analysts, homicide detectives that we actually hired. And that has really reduced the number of unfounded cases. In other words, increased the number of arrests, number one. Number two, those lawyers are going out on the scene immediately, whether it's 3 o'clock in the morning or it's 11 o'clock at night, whatever it may be. And they're able to take fresh testimony and get it sworn pretty quickly so that we can file charges. And so far, the arrest rate has gone up and the no action rate has gone down. Miami Gardens liked what we were doing so much, they asked us last year if we would replicate that same model. So we are now in Miami Gardens doing pretty much the same thing I just described to you. And that is beginning to, that's only been there about 11 months, but it's beginning also to have an impact. And the other thing it does, and I'll close on this, Nancy, I'm sorry, it's a long answer, but you know, it builds a relationship with people in the community. And that's so important. And it also gives you an immediate response. If there's a murder case or a shooting and you're at Ryder Trauma and you're surviving, but you don't hear anything about the case, no arrest is made, and you're the mom or the dad, nobody's really reaching out to you as it was before. So this being there, having these victims advocates reach out fairly quickly is starting to build a trust that something can happen and will happen in the system to make them, their families, and their neighborhoods safer.
Okay, thank you. Ms. Pearson.
Yeah, so a couple things. Number one, unfortunately, I know my opponent has a different experience on technology, but the experience she's reciting is not consistent with the experience I had or a number of the other prosecutors who I speak to on a regular basis that are still in that office. And then I also know there was an issue with regards to the Menacall case. The file got lost, so I don't know if that's a tech issue or if that's some other issue, but just putting that out there. So with regards to keeping our community safe and dealing with the quote unquote, like snitches get stitches type culture, you know, at the end of the day, number one, it has to be very centered in community policing. When we have a situation where the police officers spend a lot of time in the community building the trust of the different people within the community, they are able to hear about issues that are brewing, or be able to hear about information regarding pending cases. So that, even though that's not something within the direct purview of the state attorney's office, it would be something I would be encouraging, especially having been president of the National Black Prosecutors Association and going to the Obama White House twice as we were in the formational stages of the 21st Century Task Force on Policing. Community policing was very central to that and is very central to criminal justice reform and police reform going forward. But so something that's a little bit more within the purview of the state attorney's office is that of witness relocation. And I think part of the role of the state attorney, and something that I will be doing very aggressively once elected, is to go to Tallahassee and expand on the amount of money allocated to witness relocation, as well as to expand the criteria, because too often people can't relocate if they have a criminal history, if they have criminal convictions. That's problematic because you take your witnesses however you find them, so we should be able to afford anybody that protection, no matter what their background is, as long as they have relevant information and they're willing to put themselves at risk to find closure and justice for another person. So it's about really expanding that witness relocation so that people have the option to leave, and that also they can take more family members with them. Because again, one of the issues, and I know this again from being assistant chief, working in career criminal robbery, as well as just working in the community, that the person may get relocated, but their auntie or their grandmother lives down the block. And since they don't live in that particular household, they're not necessarily able to be relocated. So now the person can relocate, but they're leaving their family behind to also potentially be a target. So we really have to just re-examine and fight for more expansion on who can be allowed to relocate, so that way we can get that valuable testimony and close these cases.
Okay, thank you. David, you have a question?
Yes. Kathy, your office recently charged a Miami Gardens police officer for use of force against a woman who was tasered outside a nightclub. But in that case, the officer was also charged with official misconduct for allegedly lying on the police reports. And that's something that if you talk to defense lawyers, that happens all the time. Can your office be more aggressive about going after police officers who blatantly lie on police reports on possible charges of official misconduct?
Yeah, well, so in that case, as you know, we did charge him. And one of the things we did do was the official misconduct, for those that may not know, I know you know, David, was for putting false information in that report, in that A form. The other thing is we have, I think we have this thing called alert. And essentially we attempt to look at cases where maybe there's not a criminal charge like we had in that case for the battery on that young woman. But we don't believe them. And so what do we do about that? Is there a pattern there? So this team of oversight has been put together, and they are looking at those kinds of cases. And, the other thing that we talked about is whether or not there should be a uniform clearinghouse so that we know statewide who are these officers that are abusing their power, who are they that are misusing their trust that they are given in form of a badge and a uniform. And that's one of the things we don't have. So you might have a lot of different excessive force cases, like a battery, a punching when someone's restrained, but it doesn't go necessarily to a clearinghouse. And so they move around a lot from department to department. There is no uniform protocol also for excessive use of force, not in Dade County or not in the state of Florida, which is something else I think we really need to address when we move into police reforms.
Okay, thank you. Ms. Pearson, do you want to address lying police officers?
Yeah, so that is one of the most problematic areas that is probably the easiest to address. First off, the concept of an officer no-call list has been around for the last decade, and many other jurisdictions have been implementing them and using them on a regular basis. So that's something that I would implement on day one, and I'm surprised that it hasn't been done so already. Also, that is another aspect as to why I'm going to have my dedicated prosecutors working solely on police officer misconduct as well as police shooting cases, because of the fact that there can be other charges brought forth that may not be necessarily homicide or something like that, but this is an issue that has come up over and over again. And this is a great way to be able to show the community that we are holding officers accountable, especially when they're lying or misrepresenting the underlying issues that are going on. I will definitely point to, there's been a number of lost opportunities as to when those charges could have been filed on a variety of cases. For instance, according to the Miami Gardens police officer who had sexually assaulted a mentally disabled woman and lied on the police report with regards to that, and charges were never filed against him in that particular case. Now we're looking at more of federal intervention and things like that. But there are a number of cases where this could have been employed as a tactic to be able to hold police officers accountable. So we need to be much more aggressive when it comes to that. And I intend to do so through the use of my civil rights unit when I'm elected on August 18th.
That is going to have to be the last word. We do have to wrap up. And I want to thank my colleagues, Nancy San Martin, David Ovalle, and Luisa Yanez for joining us. And I especially want to thank our candidates, the candidates who are running for Miami-Dade State Attorney, the incumbent, Katherine Fernandez Rundle, and her challenger, Melba Pearson. Thank you both very, very much. And we all wish you both the best of luck. Take care. Bye-bye.